Good morning, everybody. I'm going to remind you that if you have a question, just take yourself off of mute and then just interrupt me. So as I'm going through it, I'll be able to answer your questions and that kind of thing. Hope you're all doing very well. Today, what we're going to do is we're going to go through in more detail the approved contract changes for Trek, but also we're going to go through some issues that you just need to remember. I mentioned it before maybe, but you need to remember them. In February 2021, Trek has a new requirement. If you are renewing after that point in time, you must have in your course hours, 3 hours must be of a contract course for your renewal. So that's something that's new that went in, but it starts for renewals as of February 2021. NAR's Code of Ethics requirements for Texas, we used to have legal update and ethics, and we don't have that anymore. So NAR is the one that will be able to provide the Code of Ethics requirements that says you need to complete this course within a 3-year cycle. So you have to have your NAR login and password. You'll go to your profile. It'll tell you if you've completed it or you need to complete it. Again, they make us do this requirement every 3 years. Okay, so you need to check that because you don't want to lose your standing as a realtor and a member of the association. Okay. The next one is on November 13th, NAR modified the current Code of Ethics, Article 10. It's the Standards of Practice 10-5. And the Code of Ethics applied to us in the course of a real estate transaction and real estate activity. This change to the standards of practice says that they can come after you anytime, not just in a personal, transaction where you are conducting real estate. And what I mean by that is in the event there is any discriminatory language, epithet, or slurs used by you against the protected classes, you are subject to the Code of Ethics, even when you're not in a transaction. I'm going to tell you that your broker wants you to also go to NAR. As of November 30th, this session that I have here it breaks down more of the changes to the code. It has a facilitator as well as 2 guests that come on and give you more of a reasoning behind it, examples, and other things. I spent 9 hours in training for the Code of Ethics since November 30th. And because I'm also on the Professional Standards Committee. And what has been revealed to us by the individual who NAR appointed to be the chairperson of the advisory committee that approved these changes, she is our own Lee York from Texas. She has been engaged and involved in the code forever and is an expert. She revealed to us that they get complaints all the time, NAR does, for violations. But what they had noticed is that from 2019 to 2020, I think it was June 2020, there was a 9,000% increase in complaints. 9,000%. And what happened on that was they realized that many of these complaints involved realtors' actions while they were not a part of a real estate transaction. So because of that situation, they thought long and hard, and that is when they decided to modify the Standards of Practice 10-5 that says in the event that any discriminatory language, epithets, or slur are used against the protected class, you are now subject to a complaint, a Code of Ethics complaint. So again, please go out to NAR. It's about an hour long. They're going to host them every month, but go to the one on November 30th, this one, which actually talks about breaking down the changes to the code so you have a little bit more information. Because I'm on the Professional Standards Committee, they have engaged us in going to provide us training on how, in the event I'm asked to sit on a hearing panel, the training that I will need in order to sit on a hearing committee panel regarding any of these violations regarding the standard operating practices. Any questions? I just want to let you know your Facebook page that you post within your brokerage, it is not private. There is nothing private anymore. You are never going to say anything in social media or anywhere that is not professional, period. That's how you're going to have to conduct yourself on something like that. Now, TREC changed the mandatory date because they were a little behind on getting a couple of forms approved that they didn't do through the process that went all the way up to November 10th. So because of that, TREC says that they should have their postings of the contract changes, new contract changes, as well as the new addenda on February 21st. The minute they have them posted there, then our third-party providers pick them up and get them in order so that we can use them through, DocuSign or Zip Forms or Dotloop. The problem for you, maybe as a listing agent, is that as soon as they're posted on TREC's website, anyone can use them. And so you might receive them as an offer. Some buyers agents might choose to use that form versus the waiting until the mandatory date of April 1st, 2021. Okay, any questions? Okay, the following changes that I'm going to go through, I'm going to use the 1 to 4 family contract. They're the same changes in the unimproved 1 to 4 farm and ranch condominium new contract, both complete and incomplete. Now, in part 2, I am specifically going to go through the farm and ranch contract, the condominium resale contract, and the new home contract incomplete, because besides these changes that we are going to go through, they have additional changes. Plus, those are contract forms that you don't use often. And I'm going to point out to you a better way for you to use them in benefit of your client. We've had some violations on those types of things. And so I just kind of want to bring to your attention what you might need to ask for and have in order to make sure you facilitate properly on behalf of your client. The addendum from property subject to mandatory membership in a property owners association was approved with the changes that we'll go through. And then there are 2 new addenda. The addendum regarding residential leases, and then regarding fixture leases, which are tied directly to the new paragraph 4 in the contract forms. Okay, so the first thing we're going to do is we are going to pull up the 1 to 4 family contract. Okay, so what we have here is that we have got a couple of changes that you might say they're not significant, but we still need to go through them. Paragraph 2, property change. This was a grammatical thing. They took away the the quotation marks. But in paragraph 2, improvements, while this doesn't list everything, this is probably the most common items that they're referencing. But they did remove in the last phrase, after they mention all of the permanently installed fixtures, improvements, built-in items, it says, and all other property attached to the above described real property. Right now it says all other property owned by seller, and it's just too broad, so they removed that, which is very good, because the only thing that conveys in this contract right now in paragraph 2 is real property. In the event the buyer and seller negotiate conveyance of the seller's personal property, that would always be on a non-realty item addendum because it's not real property. It's not permanently installed or an accessory. Now, paragraph C did change because they added security systems that are not fixtures. Okay, security systems were notated in to be improvements, but now they're doing security systems that are not fixtures, instead, in other words, not permanently installed or built in. And that was because on the day of walkthrough, the buyer who saw a doorbell there, all of a sudden it was gone. And so that was really remiss by the part of the seller not to have excluded it ahead of time so that the buyer knew. But it causes disputes. And the only people who are involved in those disputes, and agents, bless their hearts, that have bought Nest controls for HVAC and security system, doorbells, and all this, are the agents. They're trying to get it concluded and resolved, and then they're having to do something that's not really was not their responsibility. They also define what a control is, and it includes sellers' transferable rights to the software applications used to access and control improvements or accessories, and the hardware used solely to control improvements or accessories. So both the software applications as well as the hardware for any of these devices that are used to control improvements or accessories. Now, what does this mean? I'm going to talk about your expanded items that you're going to need to add to your checklist, both as a listing agent and a buyer's agent. And so when we finish part 1 and part 2, we're going to recap those items that you need to incorporate in your checklist when you are doing these types of transactions, listing agents as well as buyer's agents, because a listing agent has to acquire all of this information and knowledge at the time of listing, not waiting until they get an offer, because paragraph 2 parallels our paragraph 2 in our association listing agreement. And paragraph 2D is where a seller would say, buyers, I'm going to retain an improvement or accessory. So in other words, they let the buyer know prior to offer, and they mark it here in exclusion. Sometimes they say see attached exclusion and addendum, which is a part of the contract, so that buyer and seller absolutely know what is going to convey and what the seller may be wanting to retain that is real property, either an improvement, fixture, and or accessory. Any questions?
Marilyn, in the improvements, things like yard ornament, it's not actually part of the landscaping, but where does that fall?
You mean an ornament that could be removed and no damage to the property?
Well, I mean, it would leave a print where the grass hasn't grown, but like statuary like that.
Yeah, if they're not permanently affixed to the property, they convey with the they don't convey per the contract. Those are not real property. Something has to be permanently attached, either in concrete in the ground or belted down into the ground with bolts, something that would make it permanently done. I'm going to tell you, as a seller, every listing agent really needs to say, you need, while it's very lovely the way you've decorated, and I know you enjoy those, it would maybe cause a concern for the buyer seeing it, thinking they could get it. If you put it here, it denotes that they were improvements or accessories on the property based on the description that's defined in paragraph 2. Otherwise, you could tell the sellers to just remove it and restore it so that buyers won't even want to claim it.
Okay, yeah, because I've seen where people have huge pots that have shrubbery in them at the front of a house, and they list them in the exclusions, and I didn't know if that was the best way to do it.
You can, I mean, truly the exclusion paragraph here says the following improvements and accessories. And so accessories is pretty broad, but as it's defined here, you can expand the accessory and to include it as an exclusion. Anything that will make it clear to all parties is the best way to go. No problem.
Thank you.
Mm-hmm.
Marilyn?
This
is Cindy.
Yes, ma'am.
What about bathroom mirrors?
Well, if they're not permanently installed, in other words, glued, they could be affixed to either flush mounts or much like a picture would be on a picture hook. And mirrors are a part of what convey. But again, if it is not permanently installed, as I said, is glued to it or permanently installed, they're not part of the real property as it's stated in paragraph 2, B improvement. So it's really difficult. I know we've had lots of discussions with agents saying, well, how do I know? Well, you need to ask, inquire. While the listing agent may not know, right? The sellers absolutely do know. And so there's nothing wrong with before an offer that a buyer knows what is permanently attached, and you get verification on that. That's probably the best way to go.
Thank you.
Mm-hmm. Any other questions? Okay.
Yep, Miss Marilyn, it's Ty.
Uh-huh.
Very quickly, so if the seller decides to take their Ring doorbell, are they required to put a replacement doorbell there?
Yeah, they are going to convey it if they're using this new contract form. Otherwise, it would be an exclusion. And it's very likely if a buyer knows about that ahead of time, what is the buyer going to negotiate?
Okay.
They're going to negotiate, yeah, that the seller have a doorbell. So again, my thing is I never want a buyer to be surprised by something. See, that is the goal. That's Trek's goal too with modifying and changing all of this because of the kind of gotchas that happen. And I think a lot of it was not intentional because it wasn't there. Sellers thought it was theirs. My problem is when I worked with buyers, everything they saw they thought was going to be theirs when they bought the property. So
Right.
yeah, so it's better for us to reach clarity on that. Our reference point that we would rely upon would be either this listing agent asking the seller specifically and getting a response to our question, or maybe the buyer wanting to negotiate with the seller for things that they see on a non-realty item addendum if they're not permanently installed or an accessory.
Okay, thank you.
Okay, you're welcome. Any other questions? Okay, well, the first of the big changes is paragraph 4, leases. And while we had residential leases information in our contract in paragraph 9 and 10, there were no fill in the blanks. A lot of agents missed all of that information that's so vital. So now they have expanded, defined, and attached new addenda that we subject to leases. The first paragraph says, except as disclosed in this contract, seller isn't aware of any leases affecting the property. After the effective date, seller may not, without buyer's written consent. That buyer's written consent would either be in the form of the special provisions in the offer, or it would be in the form of an amendment in the event that the parties had negotiated that. A seller cannot create a new lease, amend any existing lease, or convey any interest in the property, okay, once there is an executed contract with an effective date. It would need the buyer's written consent. That would only be after the executed contract. That would only be in the form of an amendment. Now, paragraph A says residential leases. The property is subject to one or more residential leases to tenants, and the addendum regarding residential leases is attached to the contract. It doesn't say you may attach it. It is attached to the contract. And now we're going to go through the addendum. Okay. And why this was done was, as I said, paragraph 9 and 10 had no fill in the blanks, but the seller is obligated to convey all leases per the property. That's what was done. The seller was required now for our contract in 7 days after the effective date, they have to turn over all the leases, which means the addendum and the amendments, whatever, and the moving condition form. So it's in our contract now. It just was not used and was not very clearly defined. And so this is why they attached this addenda. And they said residential lease means any lease of the property to a tenant, including any addendum, amendment, or move-in condition form. So listing agents, at the time of your listing, if you are aware that the seller has a tenant in the property and that lease must convey, you're going to get all that information at the time of listing. You're not going to wait and allow the seller not to provide it to you timely, because you're going to need it before the prospective buyer makes an offer on the property. And here it says seller may not execute any new residential lease or amend any residential lease without buyer's written consent. So this is the second time we've seen this. We saw it in paragraph 4, and now we see it again in this addendum. And so it says existing residential leases will have the following status at closing. Very clear now, I think, with this addendum, much better than paragraph 9 and 10 of the contract. So the first one allows the buyer to mark a box, okay? And so the first one says termination of residential leases. And it says all residential leases must be terminated by closing. Seller shall deliver possession of the property in accordance with paragraph 10, which is possession of our contract, with no tenant or other person in possession or having rights to occupy the property. And then it says, notice, this paragraph will not amend or terminate any existing lease. Consult an attorney and refer to the residential leases for rights to terminate before agreeing to this provision. So I'm going to take a stance here. Why would a buyer mark this box when they're presenting the offer to the seller? Well, because their financing that they're doing on the property means what? They might have to occupy the property. So there couldn't be a lease that would be conveyed. The buyer would have to occupy the property per the lender's terms. Some terms are that you can't have anybody in there. Some lenders may give other terms. But what happens when a seller receives this offer and they've marked box A? As a listing agent, we're going to review this with them and tell them how serious it is, because this is very risk laden. Let me tell you, it could be a disaster for a seller. A seller has a buyer who says, I want this lease terminated. That tenant's going to be gone. Nobody's going to occupy the property after I close, right? So then the seller, as the landlord, goes to their tenant that they have in there, and they start talking to him about it. And the tenant goes, yeah, we would be open to that type of thing, right? The problem for the landlord, if they don't secure an early termination of a lease with these tenants, if the seller waited, marked this box, and a few days before closing went to the tenant and say, okay, you need to be out, the tenant could say, no, I'm not going to be out. I changed my mind. And then the seller could be in breach of the contract for not fulfilling paragraph A. So it's very risk laden. We're never going to advise a seller and interfere with their lease that's between the landlord and tenant only. They're going to have to reach resolution, most likely to protect the seller's interest. They're going to reach resolution in writing with that tenant, right? They're going to have an early termination of lease. The problem for the seller is if this buyer doesn't close, now they have a tenant who has already in writing agreed to terminate early. So as I said, it's very risk laden. There's reasons that a seller may receive this box marked on this addendum. So you have to be aware of all the moving parts. And again, it is a risk that the seller is taking on something like this. Now, paragraph B is the assignment and assumption of residential leases.
Marilyn, I have a question. What if the tenant that the property conveys and there is a lease in place and the lease conveys to the new tenant, the new landlord? What if the tenant says, I'm not getting out?
Yeah, well, that's unfortunate. Buyer's they are the landlord. We don't advise them or anything. They're going to have to comply with Texas property code and what they have agreed upon in the lease.
But if the tenant doesn't get out,
well, that's not our problem. That buyer knew that when they assumed this lease. And so it's not, we're not the ones that instruct our clients or our former clients, because we're done once it closes and funds. They're going to have to be the landlord. And if they don't know how to be a landlord, most likely we would recommend them to either a really good property manager or an attorney that is proficient and specializes in landlord-tenant rights and issues.
Okay, thank you.
Marilyn, I have a question.
Okay.
So if the landlord and seller will sell this property to the current tenant, So of course they have the lease before, then after sale, the tenant becomes to the new owner. Should we put this paragraph that the current lease is terminated in the 124 contract, or should we use this addendum?
Well, the buyer, even though they're the tenant of the property, this would apply to this. Now, it's a really a strange situation when the tenant becomes the buyer, right? Because at closing, they assume the lease and they get the security deposit at time of closing.
Correct.
So,
So I have a closing which will happen in 1 week. It's December 29th. So before I don't know this. So what we did is we do the return security deposit. So the buyer agent asked me to put this in the 12A, said, okay, we need to return this and the closing to them, which is the security deposit.
yeah, well, that's in paragraph 9 already of our contract. No monies are ever going to go into 12A1B except expenses. The security deposit, the landlords by law are required to account for all returns of security deposits within 30 days of the buyer providing their forwarding address. In the event that it's a tenant who is the buyer, they will receive a cashier's check at closing from the landlord, which the landlord will cite as accounting for the security deposit versus per the contract that they have with the lease. So it's really difficult. No monies will ever go in 12A1B. That will not satisfy the landlord having accounted for the security deposit per the lease.
So and this situation, because we haven't
Yeah,
closed
this
yet,
is really complicated.
uh-huh.
And so you'll probably need to contact me with questions afterwards so that we can kind
Okay.
of get through the rest of it. Yeah. But it is, it's good to point up when an existing tenant becomes the buyer. Well, they get that lease assigned to them. And as I said, the landlord will be required to account for all security deposits per Texas Property Code. And we're going to see that in paragraph B2 in just a second. Okay. So the assignment and assumption of residential leases, existing residential leases shall be assigned by seller and assumed by buyer at closing. And you're going to mark one of these boxes, delivery of the residential lease. You're either A, you've delivered and a buyer has received a copy of all the residential leases. Even with an existing tenant, the seller has to do this, okay? And you want it done ahead of time. In other words, you don't want paragraph B1 B marked because it says buyer has not received a copy of all the residential leases. Seller shall provide a copy of the residential leases within 3 days after the effective date. Buyer may terminate the contract within so many days after the date the buyer receives the residential leases, and the earnest money shall be refunded to buyer. So this is an out for those buyers that have not received all of those documents ahead of time or per the contract terms now, 3 days after the effective date. Those are calendar days. So please, that's why I said as a listing agent, your duties have expanded. In the event your property is subject to a lease that will be conveyed, you're going to get all of those documents secured at the right time so that you can assist the seller with having delivered them to the buyer, so that the buyer can mark this provision B1A versus B1B. Okay, any questions? Now, the next paragraph 2 is what's currently in our contract in paragraph 9. But again, nobody ever reads the detail of it because it's not fill in the blank, or it's not really jumps out at everybody. But at closing, seller shall transfer security deposits as defined under the Texas Property Code, if any, to buyer. At closing, buyer shall deliver to the tenant a signed statement acknowledging that the buyer has acquired the property and is responsible for the return of the security deposit, and specifying the exact dollar amount of the security deposit. So it's always been there. A lot of buyers who are new landlords don't do this, and that is a real problem for them because they're required to do that. This seller, as I said, as the landlord under that lease, they have to transfer all the security deposits to the new landlord. And the reason for that is because they're required to account report. That's an accounting function, and they are subject to Texas property code if they fail to do so. That's why it would never be marked anywhere else in the contract or any special provisions. Okay, any questions? Okay, well, B3, hold on to your hats. This took them so long to retool it. The Texas Association of Realtors weighed in on it. Several board members, very prominent boards around Texas weighed in on it. And they finally came up with this. Now, here's what it says. It says, except as described below, and there's a place for an explanation. And to seller's knowledge for each residential lease, A, the residential lease is in full force and effect. B, no tenant is in default or violation of the residential lease. C, no tenant has prepaid any rent. D, no tenant is entitled to any offset against rent. E, there are no outstanding tenant claims against seller involving the property. F, there are no pending disputes with any tenant or prior tenant. And G, there are no other agreements, options, or rights outside the lease between landlord and tenant regarding the property. So what happens on this as a listing agent, at the time you take the listing and the property is subject to an existing lease that will be transferred to the new buyer, you're going to show this provision of this addendum to the seller at that time. And the reason for that is everything here has to be true. If a seller doesn't tell the truth here, they could be subject to a legal battle. In case in point, let me just give you an example of it. The seller has experienced as the landlord of the property, this tenant always pays late. Do you think that's something that the next landlord needs to know? I don't know about you, but it's a material fact, and I think they would need to know that. So what we have is, if any of these things are not true at the time of the execution of this amendment addendum with the parties, they're going to explain if any is not accurate. Okay, the landlord gets to, as the seller gets to explain this, add additional sheets, whatever is necessary. But it's very important that the landlord disclose everything very well and clear to a prospective buyer prior to offer. Now, paragraph 4 is what's tricky, and this is what's unfortunately going to involve probably a very periodic update on this during the course of the contract. It says seller will promptly notify buyer if seller learns that any statement in paragraph B3 becomes untrue after the effective date. So not only is the knowledge of the seller true at this time when they sign this addendum, it has to remain true throughout the course of the contract. Seller shall cure the condition making the statement untrue within 7 days after providing the notice to the buyer. So now we have different time limits on this. If the statement remains untrue beyond the 7-day period, buyer may, as buyer's sole remedy, terminate the contract within 5 days after the expiration of the 7-day period by delivering notice to the seller, and the earnest money will be refunded to buyer. Complex, really is. If buyer does not terminate the contract within the time required, buyer waives the right to terminate. So the buyer has to comply with the time limits in here in the event that they do want to terminate. The closing date will be extended daily as necessary to afford the parties their rights and time to provide notices under this paragraph. So we have got a situation that involves a whole lot more monitoring of this periodically throughout the term of the contract. For example, a buyer's agent may send out an email periodically and say, is everything in the addendum regarding residential leases B3 still true? The listing agent's not going to answer that. They're going to go to their seller and get their response in writing, because we always want it to be the source or not the source. The seller is the only one that could attest to that and say that it is still true. But it's going to involve buyer's agents being on top of this, as well as listing agents. Here's the example that was really sad. The seller didn't really tell the buyer about the history of the tenant under the lease, right? The buyer didn't have knowledge about being a landlord. They weren't very experienced. Maybe the agent who represented the buyer wasn't assisting them in understanding all of the complex things that go when you assume a lease from another party. And so what happened was, when they signed the contract, the seller answered that, you know, everything was fine, right? No problem. Unfortunately, when the buyer got the property and it was transferred to them and the lease, and they went to go get with the tenant, they found out that the tenant had not paid the rent that month, because the contract was executed the previous month. And when they closed, the seller failed to tell the buyer the tenant is in breach of the lease. They didn't pay them the rent. Okay, so it's complex. You don't enter into these transactions representing a party without understanding it yourself. I'm not saying you're going to legally advise them, but you certainly have to know about the terms of the contract and comply with that. Otherwise, that your party that you represent could say, why didn't you tell me the landlord had to provide those leases within 7 days in paragraph 10? And it doesn't take away from the fact the buyer should have read the contract, but they're not as familiar with it and are not obligated to the same things that we tend to be obligated to in the course of our fiduciary duty for the parties we represent. Any
Marilyn,
questions?
I have a question. If you've got a case where you have a seller who has a tenant and the tenant prepaid the lease period, how would you convey that the remaining months of lease payments have to be given to the buyer?
Well, the provision in 2 requires any security deposits, but right here in 3B, it says no tenant has prepaid any rent. If that's not true, the landlord would come down here and then the buyer would negotiate that all rents for blah, blah, blah would be transferred to buyer at time of closing.
Okay, thank you.
Yeah. So as I said, leases are very complex. They're heavily governed by Texas Property Code. Landlords know how to be landlords, or else they're going to be in trouble and need to hire somebody to assist them. But as a buyer's agent and a listing agent, our duties are to assist our parties in complying with the terms of the contract. So it's very important that in the event the property is subject to this addendum is going to be reviewed thoroughly before any party agrees to any of the terms on the addendum. Any questions?
Yes. Hi, Marilyn. I currently have a client today she is the tenant of the home. She's looking to purchase the home from the seller. So would she be entitled to her security deposit back? How would that work?
It's right here. Paragraph 2 is currently in paragraph 9 of the contract.
Okay.
Mm-hmm.
Just wanted to make sure. Thank you.
Yeah. The problem is getting it right. As a listing agent, you're going to tell the seller you need to account for all of the money, security deposits, and monies under the lease at time of closing. It's not on the closing statement. Most lenders will not allow it. It might be if it's cash, but as a landlord, I would never have it on a closing statement. I want my cashier's check to be notated that this is full entitlement and settle and in success completion of the reimbursement of the security deposits or whatever else would need to be done.
Okay, thank you.
Yeah. Yeah. Look, individuals who are landlords who know their job, it doesn't have a problem. But boy, you get somebody who doesn't know how to be a landlord, and then they're going to try and pull the agent into it, and we can't go there. It's not. It's in the contract what the seller is obligated to do. Currently, it's in paragraph 9. If you need to reference it, same kind of information that's here. Any other questions? Okay. So now we're going to go back to paragraph 4, and we just went through 4A. Now we're going to go through 4B, and 4B is fixture leases, and it says fixtures on the property are subject to one or more fixture leases. For example, solar panels, propane tanks, water softener, security system. And the addendum regarding fixture leases is attached to the contract. So it's not maybe attached, it is attached. It's the same kind of thing they had to go through to define what would be contractually obligated between the parties. Now, this fixture lease has caused tremendous difficulty with both buyers and sellers, and more importantly about the agent. So again, at time of listing, as I said, you're going to have a little bit more of expansion on your checklist. You're going to ask the seller directly, do you have any fixture leases? You need to know that, because they don't convey without all sorts of stuff that you had to go through. And currently we don't have any provision for conveyance. It would all have to be added to an amendment or into the contract at time of offer. So it was not handled well. There were issues that came up, and this addendum tries to handle contractually what parties will be obligated to and the explanation provided. So it says lease fixtures are those fixtures in or on the property that seller leases and does not own, specifically the solar panels, propane tanks, water softener, security system. And then they give you a fill in the blank. Well, because sellers failed to mark that into the exclusions of the contract and let the buyer know it before offer, there were a lot of issues that came up. And so all rights to the leased fixtures are governed by fixture leases. The seller doesn't own them. The buyer can't get them because they're attached to the real property. They're governed under a leased fixture. So number one, it says buyer shall assume and seller shall assign to buyer the fixture leases at closing except the following. And buyer shall pay the first number of dollars of any cost necessary to assume or receive an assignment of the fixture leases, and seller shall pay the remainder. Buyer and seller agree to sign any documents required by the lessor in the fixture leases to assume or assign the fixture leases. So let's break this down a little bit. This is why you need all these documents from your seller with knowledge at time of listing. Here's the additional things your seller has to provide you. Number one, they have to provide you a copy of the leases. Number two, they have to find out, is this lease assumable by the lessor? Will they allow that? Number three, they have to find out what are the qualifications that a prospective buyer to assume this lease would have to go through. Is it applications, credit check, or whatever? And fourth, it has to be, what is the cost associated by the lessor for this buyer to assume this lease? That's a lot of data, but you must have all of that data, because you can't agree to anything on this addendum without having knowledge of all those things. And a buyer needs to know that before offer, because it may be the way the buyer would want to negotiate with the seller. Okay.
Marilyn,
Uh-huh.
when you're talking about cost to assume, are you talking about like a transfer fee?
Well, the lessor will determine that. The lessor may have a standardized fee, or it may be adjusted. We don't know what the lessor will charge for the buyer to assume that lease.
Okay, thank you.
Mm-hmm. 2 says prior to closing, seller will or will not remove the lease fixtures covered by the fixture leases that buyer does not assume. And it says seller will repair any damage to the property caused by any removal. Notice, any fixture remaining in the property is subject to the rights of the lessor under the fixture lease. So in the event the seller is going to remove those leased fixtures, buyer's not going to assume them, the seller is obligated to repair any damage. I'm going to tell you 2 stories about 1 and 2 that is why you have to be very concerned as a listing agent and a buyer's agent. In 1, the buyer wanted to assume the solar panels. The lessor, with the lease fixtures, the lessor of the solar panels required this buyer to make application. They ran credit check and all these other things to qualify for them to assume the lease on the solar panels. Lender found out about it, and now the buyer was no longer individually approved for the loan on the property. The buyer was in breach of the contract. Okay, so again, as a buyer's agent, if the buyer wants to assume any of these lease fixtures, they're going to do this through the lender and verify in writing that they're assuming this lease fixture will not have an impact on them being individually approved and getting loan approval individually. Any questions? Now, 2 is the next one. Seller had solar panels and they were on the roof at time of closing and funding. They had not negotiated this. I think the seller, from what the agent described to me, the seller had told the buyer that they couldn't arrange for the company to come and get the solar panels because they were going to affix them into their new property, right? The seller was taking it with them. And all of this wasn't clear because none of it was in writing. And it came after the closing had occurred. And apparently, the solar company that came and removed those panels and was going to take them to the seller's new property did damage. And the buyer of the property was devastated because there they had just acquired the property and now they had damage, and the solar company wasn't going to pay for it. And then the previous seller is saying, no, that wasn't my fault. It was when they removed all these kinds of complications. So this is why it's been added in an addendum. They are trying to really present a true, clear picture of the responsibilities on both parties governing any fixture leases that will either be assumed and assigned or that will not be, and how the removal is prior to closing. Okay. Now, the next item in B says delivery of fixture leases. That's why I told you as a listing agent, you're going to get all these things and establish, plus all those other 3 questions your seller has to provide the answers to you, because you want the buyer to always mark B1. They've received a copy of all of them and agreed to assume, right? Or B2, if the buyer has not received a copy of all the fixture leases, buyers agreed to assume, seller shall provide a copy of the fixture leases within 5 days. Remember, the leases were 3 days. Now these are 5 days effective date, calendar days. Buyer may terminate the contract within 7 days after the date the buyer receives the fixture leases, and the earnest money shall be refunded to buyer. Okay, so they had to have a part where the buyer has received them and has agreed to assume, or the buyer received them, and then once they get them, they get to do their due diligence and then terminate the contract if they don't want to move forward. At closing, it says there will be no liens or security interest against leased fixtures, which will not be satisfied either out of the sales proceeds by the seller, or except for lease fixtures covered by fixture lease buyer agrees to assume. And then they have the big note that says that, seller and buyer should consult with the lessor and their attorneys regarding the assignment, assumption, or termination of any fixture leases, because we're not going to do that for them. We're not going to advise them. I'm going to tell you, if you have a seller who says, why don't you, a listing agent, do all this for me? Here's the leases. You read them and tell me what we need to do, and find out from the lessor exactly if the buyer can assume and what the costs are involved and what is the process for the buyer to assume it. Okay, so in the event you have a seller who says, you do my job, listing agent, I want you to make sure you get the person's name, the date and time, and then their email address, because you're going to confirm in writing. Say they gave it to you over the phone, you're going to confirm in writing with your seller attached to the email back to that lessor. This was the following information that you provided it. I am relying upon your information that you have provided today. And have your seller know that. I want you to, in the next year, to be better about documenting the source of all the information that you receive in the course of the transaction, in particular when it's a seller's job to do that and they have asked you to do their job for them. Please make sure it is in writing, and that the confirmation is that the source of the information that you've acquired, because they wanted to not do that themselves. Any questions? Could you have more than one fixture lease on a property? Oh yes, that would be a wonderful day for a listing agent, because there's going to be so much data collection and fact finding prior to any offer, and that should be done very close to the time that the listing is executed, because it could be that you can get an offer the minute you put it in MLS, and you got to be prepared for those things. Any questions? Okay, so now we are only at 4C of the new paragraph 4 leases. It says leases of natural resource. It defines what a natural resource lease is. It means an existing oil and gas, mineral, water, wind, or other natural resource lease affecting the property to which the seller is a party. So again, the listing agent will have to ask the seller, give me all those leases, because we have to present those leases to the buyer at time of offer. So C1 says seller has delivered and buyer's got a copy of them. And C2 says seller has not delivered to buyer a copy of all the natural resource leases. Seller shall provide a copy to buyer of all the natural resource leases within 3 days after the effective date, and those again are calendar days. And buyer may terminate the contract within so many days after the date the buyer receives all the natural resource leases, and the earnest money shall be refunded to buyer. Make sure that when you as a buyer's agent receive all of these documents, that you not tell the buyer, oh, I've been through them, they're okay. You don't get to do that. That is the buyer's due diligence on something like that. If they need assistance with understanding the documents, they would most likely have to hire an attorney to visit with them regarding that and give them the explanation for them. We're not going to interpret those for them. Any questions?
Marilyn, I had a situation where I had been talking to somebody, this is Colleen, and we were in a situation where the seller had a portion of, like a percentage of the lease, you know, like mineral rights. What do you do with that? I mean, do you have to
It's the same thing. You still have to deliver it as the seller, even it doesn't matter what percentage you have of it.
Well, I understand, but do you have to account for the other percentage? Like if they have half, do you have to indicate who has the other half and so forth?
Well, it should be in the lease.
Okay.
They don't issue 2 separate leases.
Okay.
Yeah, one lease should govern every party's participation in their percentages. I mean, that's the way it would most likely have to read.
Thank you.
Okay, so now paragraph 5. Paragraph 5 looks very different. It's very long too. And that's the reason, because now it includes not only the current earnest money provisions in paragraph 5, but also paragraph 23 termination option. They're now combined in the new contract form. So paragraph 5A says delivery of earnest money and option fee. Within 3 days after the effective date, buyer must deliver to blank as escrow agent. Who's the escrow agent? The title company only. And it says at, you better put an address. Buyers and sellers must know where it's delivered, to whom it's delivered, and they have to have this information. Do not be negligent about not providing it accurately and perfectly. And then it says X number of dollars is earnest money and X number of dollars is option fee. Okay, so now they've included the amounts. And then it says the earnest money and option fee shall be made payable to escrow agent. Who's the escrow agent? Title company. And may be paid separately or combined in a single payment. Now, what I am going to tell you is based on the feedback from a lot of agents that I've been doing this training with, some title companies have policies already in place. Some are waiting for the Texas Department of Insurance to give a standardization of something of how this will be handled. But bottom line is, before the buyer and seller ever sign this contract, they must know what are the methods for delivery that the title company will provide. What is the process for the title company dispersing the option fee to the seller? Because now the seller gets it right away. It's receipted within 3 days of the contract, and they get to go and cash it and make sure it's in good funds, right? Well, now this will all be handled by the escrow agent with these new contract forms, okay? Now, 5A1 says, buyer shall deliver additional earnest money of X number of dollars to escrow agent within so many days after the effective date of this contract. And what happens on this is that the additional earnest money, we have buyers who say, I'm going to go under contract now, but I am going to only give so much earnest money. But then when I pass the termination option period, there will be more earnest money deposited. Okay, so that's the provision regarding additional earnest money. Why, y'all don't interfere with me. Okay, paragraph 5A2 says if the last day to deliver the, okay. Okay, so 5A2, if the last day to deliver the earnest money, option fee, or the additional earnest money falls on a Saturday, Sunday, or legal holiday, the time to deliver the earnest money, option fee, or the additional earnest money as applicable is extended until the end of the next day that is not a Saturday, Sunday, or legal holiday. Do you know what the end of the next day is? It's 11:59 p.m. They resisted, the broker lawyer committee and Trex attorney, they resisted putting 5 p.m. here. Okay. So just remember that. Again, if the last day, so if we had an executed contract yesterday on Thursday, today is day 1, Saturday is day 2, Sunday is day 3. That's a Sunday. So it fell on a Sunday. So the time to deliver would be the next day that is not a Saturday, Sunday, or legal holiday. And they would have extended until the end of the next day, which would be Monday, to deposit their earnest money and termination option fee. 3 says the amount escrow agent receives under this paragraph shall be applied first to the option fee.
Marilyn, I have a question regarding delivering the option fee. Many listing agents or sometimes even title company, they have like a mailbox or something outside their office, and they suggest you can deliver it over there if it is Saturday or Sunday and they're closed. Would you recommend that or?
Well, I'm of the mindset that if the title company has a method for delivery that will provide good funds immediately in compliance with the delivery of the earnest money and option fee, that would be the way I would want a buyer to go. If you drop it in the drop, you as the agent, you're going to have to follow up in detail because you are going to need to affirm that they did receive it. You cannot imagine how many checks have been taken in and then misplaced, and it caused the parties to be in default. So again, I would be more particular if I were a buyer. I would secure the only method that provided good funds immediately to the title company.
What I do when I've done that to deliver as soon as possible, and I've delivered it myself, I took several pictures. I took actually a picture of me in front of the place and the check, and me delivering exactly my hand putting the envelope on the box, so to make sure that I did it, and if they lost it, it's on their side. Is that not enough?
I don't know. I wouldn't be able to comment on that. I really wouldn't. I do know that title companies are going to provide, they've already provided alternative methods during this pandemic for buyers to deposit. So I would want to assure that whatever I did, I got a receipt so that we could acknowledge it right away and make sure that the buyer had complied with the terms of the contract. Okay. So here's the situation. It says 3, the amount escrow agent receives under this paragraph shall be applied first to the option fee, then to the earnest money, and then to the additional earnest money. So let's take, for example, we've deposited $1,000 as earnest money is what was required for the contract, and $100 option fee. The buyer accidentally made a mistake. They only sent $1,000. So title is going to take the $100 option fee from that $1,000 check or payment that they got, and now the buyer will be deficient on the earnest money, and that'll be a very, very dangerous situation. So whatever methodology the buyer chooses, you must make sure that they either, if they give separate payments or combine them, that it is the exact amount that is required for them to be in compliance with the contract. So you'll have to take real extra effort to make sure that is done well. Now, paragraph 4, the escrow agent says, I'm going to get a blanket authorization because I'm not going to have to go back and revisit somebody about the option fee. And it says, buyer authorizes the escrow agent to release and deliver the option fee to seller at any time without further notice to or consent from buyer, and releases escrow agent from liability for delivery of the option fee to seller. The option fee will be credited to the sales price at closing. Now, in paragraph 18, you're going to see where the escrow agent has changed it, that they, before any disbursement, they will satisfy it with good funds only. My thing is to you, as a seller, because of the situations, the sellers are not getting the termination option fee within the time of the contract terms, the escrow agent is. It could take a delay for things clearing if they didn't give funds in good funds right away. And that will cause a problem because no buyer can terminate per this paragraph 5 termination option unless they have received those funds, they're good funds, and they've received them per the terms of the contract. Do you think that the seller could have a material business statement that the buyer agrees to in the contract that says that the buyer will only deposit good funds with title for earnest money and option fee? I think that would help eliminate a lot of the issues that listing agents and sellers are going to go through in the event the buyer terminates. They may have delivered the option fee to the title company, but it hasn't been proven that they were good funds. You know what I'm saying? We have that right now happening all over the place. We have buyers that are terminating and have never delivered the option fee, and they're using paragraph 23 currently. That's not acceptable. The buyer is really risking a whole lot because now the seller has the legal remedies. If a buyer terminated improperly, the seller still has legal remedies against the buyer. So again, it's very, very important that any title company you use, you're going to absolutely know the best delivery methods for the buyer to deliver good funds. You're also going to want to make sure what is your process for dispersing this option fee to the seller. What will be the process that the seller might have to do, or will it be automatic? All these different types of things. But make no mistake, if the option fee will be credited to the sales price at closing. They're not giving you an extra box to say will not. Okay, it will be credited to the sales price. Any questions? Okay, paragraph B of 5 says termination options. So now we're going to see a lot of things that we saw in paragraph 23 currently. Termination option for nominal consideration, the receipt of which seller acknowledges and buyer's agreement to pay the option fee within the time required. Seller grants buyer the unrestricted right to terminate this contract by giving notice of termination to seller within so many days after the effective date of this contract. That's the option period. Notices under this paragraph must be given by 5 p.m. Notice it didn't say end of day. It said 5 p.m. local time where the property is located by the date specified. So on the last day by 5 p.m. they have to give notice to the seller. If buyer gives notice of termination within the time prescribed, 1, the option fee will not be refunded, and escrow agent shall release any option fee remaining with escrow agent to seller. And 2, any earnest money will be refunded to buyer. C says failure to timely deliver earnest money. It says if buyer fails to deliver the earnest money within the time required, seller may terminate this contract or exercise seller's remedies under paragraph 15 or both by providing a notice to buyer before buyer delivers the earnest money. So in that example I gave you before where the buyer only gave $1,000 instead of the $1,100 they were required, they applied the $100 from $1,000 to the option fee, but then it was only $900 of the earnest money. Seller would have a provision to terminate the contract if that were the case. That's why it's very important that this be done perfectly on something like this. Paragraph D, failure to timely deliver option fee. If no dollar amount is stated as the option fee, or if the buyer fails to deliver the option fee within the time required, buyer does not have the unrestricted right to terminate this contract under paragraph 5. That applies to any option fee, even an option fee to extend the option period. Okay. And E says time is of the essence for this paragraph, and strict compliance with the time for performance is required. Okay, so again, there are lots of things that you're going to have to make sure are very clear between the parties before they agree to this, that the title company's procedures and process and how they're going to handle this, and all the methods of delivery that would be good funds for your buyer and seller to have per the contract terms. Any questions?
Marilyn, who would be preferable to deliver the earnest money? Should we deliver it, or should we let our clients, the buyers, deliver it?
Well, it depends upon the method of delivery. If they're going to use a portal that's allowed by the title company or a wire transfer, they're going to be doing all of that on their own. We're not going to be involved in anything like that. If they have given you cashier's checks, you as their agent would be their fiduciary in making sure that they're deposited and receipted per the time of the contract.
Thank you.
Hi, Marilyn. My question is about the number of days, the option period. Are those continuous days or are they business days? Just confirming.
Oh, no. They're all calendar days.
Calendar days. Thank
Yes,
you.
ma'am. Any other questions? Okay, as I said.
Miss Marilyn, yeah. So this is not really a question, but I did have to push back a little bit on an agent about the option fee receipt. Their seller, I was representing the buyer, and the seller was overseas, and they responded with the option fee receipt on the date that they were able to sign for the option fee receipt. So it was way after the 3 days that it was supposed to be in. And I've asked them to, physically write down the date that we delivered it, which was within those 3 days.
Who did you deliver it to?
It was delivered to the title company, but they did not sign it. It was the seller.
Not. No option fee should be touched by a title company right now. No.
Right. Because they were overseas. So once they received it overseas, then they signed off on the document, DocuSign. So I just want to know.
They had a listing agent?
Say again, they had a listing agent.
Why didn't you get it receipted by the listing agent?
Well, that's what I told my client to do, get it receipted, but they did not. And so finally, the listing agent was the person to really send it over to them, but she did get us the receipt for the date that it was delivered.
That's what has to be done. And again, as I said, you should have taken that option fee and gotten the listing agent to receipt it. Many times relying upon going to a title company to deliver earnest money is different, but you should have gotten a copy of that option check and send it over to the listing agent and get them to receipt it within the terms of the contract. That's the way you need to handle it until we get these contract changes.
Yes. Thank you.
Marilyn, I have a question. Can a buyer stipulate that the days are business days rather than calendar days?
The parties can modify the terms of the promulgated form, but they would have to be very clear about what they were, enumerating. Anything different than what's in the promulgated form has to be clear, and the seller might be willing to accept that. That would be between the parties. Any other questions? Okay, the next paragraph that has been expanded is paragraph 8, and that is brokers and sales agent. From paragraph 4, because leases are there, paragraph 4 now about the disclosure about an agent representing a party that they are related to or in a business entity with is still here. It's in A. And B is broker's fees. All obligations of the parties for payments of broker's fees are contained in separate written agreements. Okay, Since all of you are very sleepy today, I'm not going to ask you to answer all these questions. So now we're going to talk about what are separate written agreements. Okay, let's just rehash. Number one, listing agreement. It's between the listing broker and the seller. Seller says, I will pay you this much in fees, right? So the listing broker puts it in MLS. That's a unilateral offer to the buyer agent. Make sure at time of offer you have secured a copy of what was in MLS. Okay, that's the best way for you to verify that as a buyer's agent. The other separate written agreement could be that the seller is a for sale by owner. We represent the buyer. We've gone to them, and now we're going to secure in the registration agreement between broker and owner that they're going to pay the broker. Okay, or it could be that we have agreed in a registration agreement between brokers. This is how we're going to compensate the broker's fees. Or lastly, it could be where your buyer has said, I'll pay the broker's fee, and it's in our buyer-tenant agreement. So we have lots of different methods for separate agreements. I just want you to understand what they are. Any questions?
Okay. I know it might be a little bit off topic, so maybe in the future, or if I can talk to you about that for sale by owner, representing, if you're like a buyer's agent and then you find something where it's for sale by owner. I would like to hear a little bit more about how you could do that.
Okay, well, you need to contact me and I will help you in securing them, making sure that prior to offer that you always secure the right documents from the for sale by owner. Okay.
Okay, thank you.
Paragraph 10, possession. Paragraph B was where we had the provisions about leases that nobody read. Paragraph 9.5 is where it talks about that the seller will transfer the deposits and the buyer has to notify the new tenant. Okay. So now in B, all they're going to say is after the date, seller may not convey any interest in the property without buyer's written consent. So it's no longer about leases. It's just purely about the property. Could be the residential lease, fixture leases, or natural resource lease. Again, this is the third time we've seen this. So a seller cannot do something in conveying any interest in the property without the buyer's written consent. That would be in the form of an amendment if it's not secured at time of offer. Okay. Now paragraph C is new, and listing agents, this is another one of your items that is going to be expanded, is at the time of listing, you're going to have to ask the seller if they have any smart devices. That means a device that connects to the internet to establish remote use, monitoring, and management of the property. 2, items identified in any non-realty items addendum, or 3, items in a fixture lease assigned to buyer. At the time seller delivers possession of the property to buyer, seller shall 1, deliver to buyer written information containing all access codes, usernames, passwords, and applications buyer will need to access, operate, manage, and control of the smart devices. And 2, terminate and remove all access and connections to the improvements and accessories from any of seller's personal devices, including but not limited to phones and computers. So here's my advice to you as a listing agent. You get all of this information, you're going to show this is what you're going to have to agree to in the contract that we will be presented hopefully very soon. And so what you would tell the seller, if you happen to use usernames and codes and passwords that you use over and over and over again, it might be good for you to contact and reset up temporary ones that you would use that would convey to the new buyer. Right? Makes sense. Some people are not thinking about identity theft and other things. And I'm going to tell you, as agents, it puts us in a horrible situation. And so what you're going to tell the seller is, you don't get to give me any of this information. Here's what you're going to have to do. In a sealed envelope, you're probably going to ask the escrow officer at the title company that upon the transfer of the property, when does that happen, the transfer of the property?
After closing and funding.
It's only funding. Has nothing to do with closing. Funding. Funding is the act where ownership changes. So who's the first party that knows about funding? The title company. So that's why your seller would place in a sealed envelope with instructions to the escrow officer at the title company, provide this to the buyer when it funds. Not before, but after funding, okay? You're not going to get them as the listing agent. You're not going to get them as the buyer's agent, because that is all private information being passed around. And what if the new buyer doesn't change any of the code? You know what I'm saying? It just opens up a huge issue for you. So again, just make sure that when they deliver possession of the property, that's at funding only. Don't do all of this ahead of time. Have the sellers place all those instructions in writing to the escrow officer at the title company, and instruct them. And then the seller would also have to prove to the buyer that they've terminated any access and control connections to all these improvements and accessories from their devices. Any questions? I don't know about you, but with all these changes, your listing appointment is not going to go quickly at all. It really isn't. The next change that we have is in paragraph 18, escrow. And again, I mentioned it in paragraph 5 because the escrow agent put a statement in paragraph 5A regarding disbursement. Okay, they're not going to disperse anything until they know they have good funds. That's why personally, as a buyer, I would only deposit good funds. I wouldn't wait for it to clear anything. And so they've added in paragraph 18A, escrow agent may require any disbursement made in connection with this contract to be conditioned on escrow agent's collections of the funds acceptable to escrow agent. So we need to make sure about that. Paragraph 18B was retooled because the prior language in there regarding how an escrow agent can deduct expenses that they have been asked to take on in behalf of a party to the contract or terms of the contract. So it says, escrow agent may deduct authorized expenses from the earnest money payable to a party. Authorized expenses means expenses incurred by escrow agent on behalf of the party entitled to the earnest money that were authorized by the contract of this party. I'm going to advise you, make sure as agents you never authorize any of those expenses. Otherwise, they're going to make you pay for them. Case in point, the one that we keep having a recurring theme on are surveys. Here's what happens. The buyer wants to get a survey per paragraph 62, and they ask the title company to help them. Title company sends something to a buyer. Buyer signs the authorization and says that I'll pay you for that. And then they order the survey, right? Now, farther down in the contract terms, all of a sudden we're getting very close to the end, and the buyer has an ability to terminate the contract with giving written notice to the seller, right? And get their earnest money back. They do that, and then what the escrow agent does is deduct that survey expense from the buyer's earnest money. And a lot of times it's a gotcha, and the buyer didn't know that. So as a buyer's agent, make sure you stay on top of this in the event your buyer is acquiring any expenses that would have to be paid in the issue of them returning the earnest money per the contract. Same way with sellers. Any questions? Okay, the next change is notices. All notices from one party to the other must be in writing and are effective when mailed to, hand delivered at, or transmitted by fax or electronic transmission as follows. This should never be blank. It should always have the method that the buyer and seller wants to receive notices. It can also be an addition. It can be your email address if you want to be notified at the same time that the parties have the right to notify each other with notices per the contract. It's used only for notices. Buyers and sellers say, well, I don't want anybody to contact me. Well, I'm going to tell you, the buyers signed a buyer-tenant agreement, seller signed a listing agreement, and they said you're their exclusive agent, and they're just going to have to tell if a party's contacted them, you're going to say, you must go through my agent per my agreement with the buyer agent. You must go through my the listing agent. In other words, whatever you have to do, they're going to have to stop it rather than engaging with the party that's contacted them regarding something other than a notice that is required to be delivered. Okay, again, it'll never be blank. Paragraph 18 points to it, so you can't have any blanks. If they are blank, then that means that the agents, the respective agents, will have no life. They will constantly be connected to be alerted, let their party be alerted the minute a notice would come in. I mean, they can't go anywhere or do anything. So that would not be the most desirable situation. The reason Trek created this is because of all the complaints that the parties, the buyers and sellers said, well, I tried to get in with my agent, but they were out or they were busy or they didn't respond. And time is of the essence on many of our notices. So that was the reason it was created, because they can deliver this notice per the instructions here, and it would qualify for being able to give those notice per the contract terms. Paragraph 22 adds two new addenda that are directly related to paragraph 4 leases, addendum regarding residential leases and addendum regarding fixture leases. 23 is going to be gone. They renumbered the consultant attorney before signing with paragraph number 23. Now on the broker information page, they have added a team name. For that is many MLS systems will give teams credit for things, but I'm going to advise you that you better make sure this is all complete. There was a Trek complaint where an agent was in violation because they failed to complete all their information on this page. So please make sure that is done. The other thing is the associate name really needs to be the individual that has performed the fiduciary duty face-to-face with the client. And the reason I say that is we had an issue where the lead agent wanted to be on all the contracts, but one of the agents on their team was the one that actually was performing the fiduciary duties for the party. Well, that became a legal dispute, and it was revealed that the person on the contract, the associate's name, had never ever met this party, never performed one fiduciary duty. They did not have any E&O coverage, and so they were going to be subject to paying everything. So again, Trek's very clear about this. It is the associate that is performing the services. You must always have all of this information completed properly, the brokerage license number, who you represent, the licensed supervisor of the associate, their license number, and all the information about the office address, city, state, and zip, and the phone number. Any questions? Okay, so at the bottom of this form, they retooled this information quite a few times. It says pursuant, it's a disclosure. It says pursuant to a previous separate agreement, such as a MLS offer of compensation or other agreement between brokers. And I talked about those two documents. It would be a listing agreement, or it would be a registration agreement between brokers. Listing broker has agreed to pay other broker a fee, and then you fill in the blank. This disclosure is for informational purposes and does not change the previous agreement between brokers to pay or share a commission. So if they offered you 4% in MLS as a buyer's agent, you would only put 4% here. You wouldn't put 5%. Okay, you're only going to put what the unilateral offer of compensation is, or what the registration agreement between brokers that might have modified that is. Any questions? Okay, the option fee. Well, when these contract forms are used, only the escrow agent can receive the option fee. So again, they've struck through the seller or listing broker. They are no longer able to receive and receipt option fee with the new contract forms. Any questions? Okay. Now, the next one that we're going to look at are the changes that are in the addendum for property subject to mandatory membership in a property owners association. And it says not for use with condominiums. That's why I'm going to go through the condominium contract next time, because it's embedded in paragraph 2. Condominiums by Texas property code law are handled differently and treated differently than a property owners association.
Marilyn?
Okay? Yes.
I'm going back to the previous form. Does the option fee, you're saying that the option fee is no longer paid to the seller or the listing agent?
Under these new contract changes, that would only be after the contracts are posted by a TREC. You can't do it now. The seller and listing broker, once these become mandatory or are used after TREC posts them in February, only the escrow agent can receive the option fee. Correct.
So we send the option fee and the earnest money to the same place?
To the agent. It's made out to the title company, the escrow agent.
Wait, the option fee is made out to the escrow agent?
Correct.
Wow.
Under these new contract changes, not now, but once these contract changes are posted in TREC or when they're mandatory use as of April 1st.
Wow. Okay, thank you.
You're welcome. Okay. So now the addendum, these changes, I went through these in June with you. They didn't change them. They're the same. My problem for the listing agent is that they are going to need to, at time of listing, they're going to need to know exactly what are any fees and deposits or reserves that a buyer might be obligated to pay for the transfer of the property. You have to know those information. Because now, instead of D saying that the buyer's going to pay for those deposits and reserves, C now says fees and deposits for reserves except as provided by paragraphs A and D. Buyer shall pay any and all association fees, deposits, reserves, and other charges associated with the transfer of the property not to exceed X number of dollars, and seller pay any excess. So for a listing agent, you'd have to know how much was involved before your seller would ever agree to allow the buyer only to pay $100, and the seller says, well, how much is the rest? You would have to have that information. And I'm going to caution you very quickly on this. If the seller says you find out from the association, you know, the listing agent has to do their job a lot of times, you're going to record again who you're speaking with, the date and time, and their email address, because the minute they give you information, you are going to send it back in writing and attaching your seller on it, saying we are relying upon the information you have provided. This is the following information for this property, what deposits will be, reserves will be, and any fees associated with the transfer of the property. Okay, so your seller would have to know that, because if the buyer was only going to pay $100, which a lot of times I see very low amounts, the seller has to know, well, what's the remainder? Because it's got to be on my estimated net sheet before I agree to this offer, that kind of thing. And if buyer's agents, if they get into a negotiation and the seller comes back and says, no, I will only agree to this if the buyer pays $1,000, you probably want to know from the listing agent, what are those fees? Do you know what I'm saying? To confirm all of those reserves and fees and those things. And the listing agent should have them. They're the first line of defense for the seller to provide all this information. All right, any questions?
So prior to these contract changes, Marilyn, the buyer would then have to pay, like, for example, a cap fee, even if on item C, they only agreed to say up to $350. Those cap fees can be like over $1,000.
Well, capitalization fees, if a lot of times it doesn't involve the association. They're not the ones assessing them or collecting them. They're separate entities that they may be obligated for the covenants of the property to pay it. But the seller has to notify the buyer prior to offer. There is a capitalization fee of X number of dollars or whatever percent at time of closing that you'll have to pay. The buyer can't have any surprises about that. And where we've run into issues is where a buyer agent is not familiar with properties in those developments. And they're all around Houston. And it causes tremendous difficulty because now a buyer is looking at a substantial increase. Once the sellers have provided notice to the buyer, and a lot of times you'll find it in agent remarks in the MLS, and it will say capitalization fee 1%, blah, blah, whatever it is, the buyer now knows that. Once the buyer usually knows that ahead of time, they negotiate it at time of offer with the seller in special provisions. So again, if you're not familiar with areas and developments, you're going to get with somebody who is an authority of it, a title company that maybe does a lot of closings for those Any other questions?
Thanks, Marilyn. You cut out at the end, but I can call you after about that.
Okay. Any other questions?
I'm quitting.
No, you're not, Cindy.
This is so complicated. It's unbelievable.
Well, I've been licensed since '93, and I think these changes that we see, I know the termination option caused a lot of problems, and they retooled that over the years. But this is the most sweeping changes. And so no agent who doesn't connect and really understand all these changes, they really can't help their buyers and sellers very well. And I don't want the agents to be caught in that. I want them to be aware of it. It is going to take a little bit more time from a listing agent's perspective and maybe from a buyer's agent's perspective. Listing agent has to know all of this at time of listing. Buyer's agents are going to need to acquire that information prior to the buyer presenting an offer in the best way that they can. As I said, next time we meet, which will be next year, it is hard to believe, I'm going to go through the new home, incomplete contract, farm and ranch, and then the residential condominium contract, because these are forms that we don't use as often. And when we do use them, sometimes we might be remiss in making sure we pay attention to certain provisions that are unique to these forms that would assist our clients tremendously in facilitating the transaction for them.
Does that include the new constructions? And
Well, new home incomplete, that is a new construction incomplete. We're going to go through that form because it has other changes other than the ones we just reviewed. Any other questions? Well, since this will be the last time I get to visit with you this year, I am really hoping and praying that 2021 is a much better year for all of us. And what I wish for you during this blessed, holy, and holiday season, Merry Christmas, Happy Hanukkah, it's concluding. Today is my 49th wedding anniversary.
Oh,
Congratulations.
Happy anniversary.
Congratulations.
Happy anniversary.
Congratulations.
Miracles happen every day.
Congratulations.
Every day they happen.
Yes.
And I'm living proof of that miracles happen every day.
Yes.
And what I'm going to tell you is my hope for you is that your heart will be filled with hope. Hope doesn't do anything. It is infectious as COVID. It will rub off on your clients that you work with, the associates in the transactions, as well as associates that you are with in your market centers, and to those that you love and hold dear. Hope is the best thing we have. And so for you, I wish you your heart to be filled with hope.
Same to you, Marilyn.
See you next year, the good Lord willing.
Merry Christmas. Merry Christmas.
Thank you, Marilyn.
Thank you, Marilyn.
Thank you very
Thank
much.
Happy holidays, everyone.
Happy holidays.
Thank you.
Guys.
You will all
Thank
get the
you.
recording later today, and then early next week, it will be in our YouTube channel as well. As I mentioned before, I'll be on vacation. So after Christmas, I will get back to you.
Thank you, Gabby.
Thank you. Take care. Happy Merry Christmas, everyone.
Do we need to
Merry
sign out?
Christmas.
Gabby, are you going to put the QR code up?
No, I'll sign out everybody today.
Thank you, Gabby.
We should do that,
Gift,
Gabby.
going away
Merry
gift.
Christmas.
Thank you.
Thank you. Take care.
Enjoy.
Bye.
Thank you.
Bye-bye.
Bye.
Don't cry. Do not cry. You're just